Let's start. The appellants being legal representatives of one Ramchandra who was accused of offences under section 409, 468 read with section 471 of the Indian Penal Code have filed this appeal against the judgment and order dated 28/6/2006 of the High Court of Andhra Pradesh at Hyderabad, dismissing their petition under section 482 of the Criminal Procedure Code. Ramchandra, since deceased, who was the husband of appellant number 1 and father of appellant numbers 2 and 3, was prosecuted under the aforesaid section in respect of misappropriation of fund. He was charged with misappropriation of an amount of rupees 6.57 lakh during the period 31/7/1987 to 29/6/1988. Along with the Subhraj was charged as accused number 2. In October 1991, Ramchandra expired during the trial. The trial court acquitted the accused number 2 Subhraj, judgment dated 25/10/1993. However, the trial court observed on the basis of oral and documentary evidence that Ramchandra alone committed the offence as alleged by the prosecution. Further, that there was no oral or documentary evidence placed before the court to show that Subhraj is surviving accused assisted Ramchandra in committing the alleged offence. In effect, the trial court found Ramchandra responsible for the offences, though he could not be adjudged guilty since he had expired para. In 1997, the state moved an application under the Criminal Law Amendment Ordinance 1944 within bracket Ordinance number 38 of 1944 for attachment of property of the appellant under the criminal law. Thereon, the district judge passed an order of interim attachment under clause 4 of the ordinance on the basis that Ramchandra has committed the scheduled offences or that he has procured money or the property in question from the proceeds of such offence. The district judge issued notice calling upon the appellants to show cause why the order of attachment should not be made absolute. In this order, the district judge observed that according to the state, as many as 30 items mentioned in the schedule were acquired by the said Ramchandra, either in his own name or his wife's name or in the names of his son, due to illegal amounts drawn by him, and a case was filed against Ramchandra as accused number 1 and Subhraj as accused number 2. District judge further observed that the trial court, that is first additional district Munship Kuda, found Ramchandra had committed the offence as alleged by the prosecution, and therefore the said Ramchandra committed the offence. It was observed by the Lydet district judge that Ramchandra had been found to have prepared a bill in the fictitious name of 221 lectures during the relevant period, and he had drawn cash on the basis of the bills, including the bogus bill since May 1991, and drawn about rupees 38 lakh of rupees 40 lakh. Thereafter, on 1/10/2002, the Lydet district judge heard both sides and made the order of interim conditional attachment absolute. He observed that the High Court has refused to interfere with the order of interim conditional attachment, and though no counter affidavit had been filed by the appellants, the Lydet district judge observed that the appellants have failed to prove that the properties as mentioned in the schedule are the self-acquired properties of U. Ramchandra, and therefore the order is being made absolute para. The appellants then challenged the order of the Lydet district judge making an interim attachment absolute by way of an petition under section 482 of the Criminal Procedure Code. The Lydet single judge held that the amount misappropriated is 6.57 lakh. Strangely, on the basis of the charge sheet, the Lydet single judge also observed that Ramchandra, who alone had committed the offence and not Subhraj, must be taken to have misappropriated the said amount, since the trial court held that the latter no to be innocent against the aforesaid order. The appellants have preferred this appeal. Where Lydet senior counsel for the appellant submitted that the scheme of the Criminal Law Amendment Ordinance 1944 does not permit the district judge to confirm any attachment of the property, though the criminal court has not validity convicted and found the accused or the person whose property is sought to be attached as guilty. Learned counsel submitted that in this case it was not possible for the criminal court to have convicted or found Ramchandra guilty since they expired in 1991 during the trial. In fact, according to the appellants, no application for attachment could have been made under these circumstances. Learned counsel for the respondents strongly opposed the prayer and submitted that the appellants may not be allowed to remain property property obtained by ill-gotten means, and it was legal for the learned district judge to have passed the order of attachment in respect of such property which was admitted with the subject matter of the charge sheet. It has therefore become necessary from us to examine either the property of a person which was merely case of an offence of misappropriation but who died during the pendency of the criminal trial can be attached in the hands of his legal representatives under the provisions of Criminal Law Amendment Ordinance 1944. As far as making the application for attachment, we find that the law authorities the state government to make such an application even though proceedings against the person may not yet have resulted in a conviction. This is by virtue of clause 3 within bracket 1, which empowers the government to authorize making of such application to district judge where it has reason to believe that any person has committed any scheduled offence. But however, clause 3 requires the government to make such an application to the district judge with the local limits of whose jurisdiction the said person ordinarily resides or carries on business, thus clearly requiring the existence of such person. It excludes the possibility of proceedings against a dead person. Clause 4 of the Act empowers the district judge to pass an order of ad interim attachment prima facie grounds for the believing that the person in respect of whom the application is made has committed any scheduled offence or has procured any money or property thereby. Stop. Thank you.